You were Destiny Collins. We issued a warrant for your arrest because you failed to appear for court, ma'am.
The paperwork, I told him the same paperwork. He said I was supposed to appear today. If that's the case, my bail's going company should have told me the same thing. But my court date was for today.
You were ordered to appear 11/22 of 24.
I got out of jail today. I was released from jail on Wednesday of this week, last week that just passed. So it was no way possible. I could have made it to court that same day. I got released from jail again. And I didn't get released from jail till Wednesday at like 1 o'clock in the afternoon. And then also I have the picture. I didn't bring the physical copy because I forgot it, but the paperwork that they gave me when I was leaving, that said my conditions. I have a picture in my phone with my name on it. It says today at 8:30 in the morning. So I showed up today. If that was the case, I would have showed up when I was supposed to come to court. So I don't get that. And I just sat in jail for a week and a half. I cannot go back.
You issued the warrant on the 22nd, right? This is Miss Collins. She's not on docket today.
What's the case number?
252-6615.
Can I show you the same picture?
She was on the docket on the 20th. She was supposed to be here on the 20th, correct?
The bond paperwork shows, let's see.
I'm confused. I'm confused.
It's not open.
Can I grab my phone and show you my
Don't
picture?
talk to the prosecutor, please. You're not allowed to. I'm trying to figure out what's going on, because if there's a problem and it's not your fault, I will reinstate your bond.
Judge, so on 11/20, she failed to appear. Defendant not present in holdover is what Jamae wrote on the reset. So she wasn't brought up on the 20th. So she rolled it to the 21st, and then the surety bond was posted. The surety bond says 11/20. So it seems to contradict itself. The 20th,
So whoever wrote the bond did a mistake, because they put
whoever handwrote 11/20
back in time as opposed to, so what, you said you have paperwork that says that you're supposed to be here today?
I left the physical paperwork at home, but I had my brother send me a picture because I forgot it. I can show you.
Yeah, sure. And you can give it to Deputy and she'll. You see that it shows today's date?
Yes, Judge. November 26th at 8:30
Okay,
a.m.
all right. Yep, you're right. Okay, I'll reinstate your bond. Okay. So it looks like while you were in custody, they appointed you a lawyer. I don't know that Martin even knows. I mean, there's no way he's gonna know.
Especially if she's not on docket today.
Right.
No?
Oh, I have his number. I'll call him. Let me see. Martin.
Yes, Judge.
Hey, how are you? I have a Miss Destiny Collins that's on docket today. Are you in the building? So you were appointed, it looks like, while she was in custody. Say it again? She was in custody in Fort Bend. Huh. Okay. Do you want to stay on the case or do you want me to appoint someone else? Hey, okay, no problem. You just tell me. So that's it? Done. We'll do it. Okay, okay, fine. Can you pull up her NCIC, please? So we can, I'm gonna take Martin off
Okay.
because he's not working with us. And do you mind appointing someone else for the time being, please? Ms. Collins, you're charged with assault, bodily injury. You're facing a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
August 8th, 2024, a deputy was dispatched to a bar and grill in Harris County, Texas regarding an assault. The complainant worked at the bar as a bartender. Defendant came behind the bar and began striking the complainant multiple times with a closed fist to the face and upper extremities, causing pain. The complainant began to fight back to defend herself. During the fight, a crowd of people surrounded her, and some individuals who she did not know began to stomp and kick on her while she was fighting on the ground. Complainant
Stop and kick the complaining witness.
That's not true.
Stop, please.
Yes, the complainant stated during the fight, a crowd of people surrounded her and began to stomp and kick her while she was fighting on the ground. She stated that the fight lasted approximately 2 minutes. The complainant and the defendant did not know each other and stated that she did not know the defendant well enough to fight her. The complainant stated the fight ended because someone yelled out, "I'm calling the police."
Okay. Tell me, does she have anything else that's open at the time now?
She's currently on probation out of Galveston County for theft.
Yes.
I think you had mentioned something about Fort Bend, so we're looking for.
Lord, we're hitting the Tri-County area now?
We're not showing anything out of Fort Bend, Judge, but she is on probation out of Galveston right now.
She may have been in custody in Fort Bend. I don't know. So is there's run full NCIC, please. Ms. Collins, I'm going to find that there's probable cause to go forward with the case. I'm now ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. I'm going to do everything in my power to protect my public in every single way, shape, form, manner. And if you become a danger to my public, I am first off going to put you in jail. Next off, I'm going to make your bond so high you're going to flip. Do you understand? Do not go back to this bar or any other bar. I'm prohibiting you from going to any establishment where 51% or more are beer, liquor, any kind of clubs. You're not to go anywhere of this nature. Do you understand? Does she have a felony theft or does she have a misdemeanor theft? And then what else is open? What kind of criminal history are we talking?
Felony theft, Judge. And I believe that's her only history. And Alex is looking into the Fort Bend case as well.
Your Honor, I don't have any record of her case in Fort Bend. Looking at the county clerk website for Fort Bend, I don't see any cases open with her name and date of birth.
So the only other thing you see is it a probation that she's on?
Yes.
For Galveston.
Oof.
Yes, Judge.
Yes, Judge. 2 years deferred from Galveston.
How old are you, ma'am?
23.
What do you do for a living?
Right now, I work 2 jobs and I live alone. I live in the Fort Bend County area.
How much money do you make a month, ma'am?
My monthly income, I say my intake probably about 3,800.
I need you to fill out an application because I don't know if you're going to qualify for an appointed lawyer, ma'am. And I'll take a look at the application. The only thing I'm going to tell you is that when you're on felony probation, you're supposed to be extra special good. And when you're not, they usually file motions to revoke. So I would be on the lookout because if you're on probation or parole at this time, it's very possible that they issue a felony warrant in that case with the fact that you picked up this new case. So understand, no alcohol, no drugs. Do you understand? Okay, do you mind giving an application, please? All right, I'm gonna have you fill out the application and then we'll, do not leave until you sign all our bond conditions, ma'am. Sir, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, sir.
On March 28th, 2025, an officer was in the process of serving a capital murder warrant on a suspect in Harris County, Texas. While conducting a felony stop, the defendant, who was identified by his Texas ID card, pulled up on the officer's perimeter, got out of their motor vehicle and began walking to the residence where the murder suspect was. The officer supervisor ordered the defendant to stop and stay right there. The defendant refused and continued to ignore officers while walking towards the residence. The officer supervisor ordered the defendant to step back multiple times and then grabbed the defendant and took him to the ground.
Him?
Yes, Your Honor.
Was he the capital murder suspect?
No, Your Honor.
I live there.
Stop.
Oh, sorry.
I believe that they were in the process of serving a warrant on someone else at the residence, and that's when they came in contact with the defendant. Ordered him to stop. He refused to stop going towards the residence, Your Honor.
They served the warrant. What ended up happening?
Looks like after refusing commands, there was a brief struggle where he was detained.
Was the murder suspect there?
I'm not sure, Your Honor. It does not say. I have no further facts that show if the warrant was service was complete on the warrant or not, Your Honor, or completed at the time. I just believe they were in the process and believed him to be at the residence, and that's when this incident occurred.
Read it again. Do you, if you don't mind?
Yes, Your Honor. On March 28, 2025, the law enforcement officer and Squad 5 of the Houston Police Department's Gang Division served a capital murder warrant for a suspect observed inside a truck at a nearby residence. While conducting a felony stop, the defendant, who is identified by his Texas ID card, pulled up on the perimeter, got out of the vehicle, walked to the sidewalk, and began walking to the residence where the murder suspect was. The supervisor then ordered the defendant to stop and to stay right there. The defendant refused and continued ignoring officers and walking towards the residence. The supervisor ordered him to step back multiple times, but the defendant was once again ignored the officers. The law enforcement officer grabbed the defendant and made him off balance and the ground.
Okay, so now, but when you first started, you said they were going to a capital murder suspect in a car.
Yes, Your Honor. That's what, so I was originally reading the summary, and I'm going straight from the gems down, Your Honor. It looks like the suspect was observed inside a truck at a nearby residence.
So the suspect is not even in the residence. No.
Then they later state that there was that the suspect, that the defendant here was walking towards the residence where the murder suspect was. I'm not sure, Your Honor. I have nothing further.
I find no probable cause in your case. Just be careful, man. When you get into a pissing match with
I understand.
who's going to win?
They are. I understand.
No.
Yes, sir.
All right. Good morning, Miss Gill.
Good morning, Your Honor.
I wanted to bring you out because we're talking about you, and it's only fair that you get to hear what's transpiring since these are your cases.
Yes, sir.
I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Or, well, hold on. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On March 25th, 2025, officers were dispatched to 15357 Wallaceville Road in Harris County, Texas, regarding an FHDI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Bill Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited, and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time. The
So are
complainant,
you telling me that now it was intentional?
the complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who struck the vehicle. The estimated damage from the complainant was around $4,000, and the defendant stated she didn't stop because she was hungry and colored.
And what?
Colored.
Color.
Yes, Your Honor.
Can you look up to see if she has a valid Texas driver license?
Yes.
Ms. Gill, I'm going to find that there is sufficient probable cause to go forward with your case. Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle, and now an FSGI. I am taking away your privilege to drive. You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt. I can have a contempt hearing. I can have a contempt. Finish.
I'm so
please.
sorry.
Finish.
I'm a commercial driver.
Really?
Yes.
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. I truly am at a loss with the attitude.
Okay.
Truly.
Okay.
In this case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally. Because
Wow.
allegedly
Yeah.
hungry and colored. So now, this is an affidavit, and I hope that you take it seriously. Because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor. May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. She has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because During this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so, as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and she is willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100. And
So I appreciate your argument. She's technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what, Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road is that you are a danger to the public, and your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always, I mean, really,
don't say anything.
how many people died this weekend on the road because of the reckless and wanton actions? All we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping
Don't say
me.
anything.
I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this. Okay? I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children have trauma, okay? And I have no insurance for the medication, and I have not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
Okay.
I understand that, but at some point, your actions become your own, right?
You don't understand. I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
It's
not.
so true. It's so true. And you know this. You know what I'm talking about.
I call out discrimination when I see it on a daily basis, ma'am. I don't care who it is. I don't care what color. If they're a small farm animal, I don't care. I call it when I see it. The only thing, because I don't know them. The way I get to know them is paper. And they tell me what happens in the case. And from what I see here and what has transpired here within the last 10 minutes. Really?
Officer Harris did not read me my rights.
Well, I will let
They've been mishandling me like this for years already, okay? I have the right to tell you this. And I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
Yes.
She just brought me to jail.
You guys speak about that. I'll tell you, look, here's what I'm gonna do. I'm gonna leave your bond at $1,000 now. All right, I'm not gonna raise it to 5, but I can't continue to give you a PR bond.
From employment too.
Listen,
Okay.
do not drive. It's the only thing I'm asking you to do.
I'm a commercial driver.
Don't pick up a new
Yes,
case
sir. Yes, sir.
and just, all right. Come on. Justin.
The only thing that she did wrong at the day and time was drive a vehicle.
With cocaine, alcohol in her system, beer in the car at a .20. As a result.
Yes, sir.
Can you please read to me what happened?
Yes, sir. This crash happened back on December 24th of last year. Officers were advised of a 4-vehicle crash at 5:37 a.m. on the 6300 block of I-45 South here in Harris County. Investigators observed massive damage on a Chrysler, indicating a head-on impact, massive force damage on a Mitsubishi, indicating a T-bone impact to the driver's side. Officers spoke with a HFD firefighter who was on his way to work and observed the Chrysler strike the Mitsubishi. The Chrysler cut in front of him, causing him to swerve to the right and hit an Amazon truck. He states that this defendant was the driver and sole occupant of the Chrysler. And the driver of the Amazon truck confirms the wheel witness's story and stated that he clipped the Chrysler as he was coming to a stop, excuse me. The complainant was taken to the hospital where she was pronounced deceased. Officers observed an unopened beer can in the driver's seat of the Chrysler. This defendant stated that she was the driver and that she struck the vehicle. They observed a strong odor of alcohol in her breath, red glassy eyes, and slurred speech. She was transported to the hospital and a DRE arrived and she was Mirandized and she waived her rights. She stated that an SUV was stopped in a lane and she tried to swerve to avoid hitting it and then crashed into the other vehicle. She admitted to consuming 4 to 5 12-ounce twisted teas and smoking marijuana.
And alcohol in the car while she's driving.
Yes, sir. SFSTs were done. She scored 6 out of 6 on the HGN. She did not have vertical gaze nystagmus, and officers observed a lack of convergence. They were not able to do the walk and turn and one leg stand due to her injuries of a broken arm and sternum. There was a blood warrant and residual search warrant that were done, and her blood, Your Honor, came back at a 0.025 for ethanol, and she had. Yes, 0.25, yes, sir. And then she had marijuana and cocaine in her system.
And what's the offer that you have worked out?
We worked out an 18-month probation offer with 7 days as a condition, Your Honor.
I don't think that's enough. The fact that there's a dead body in this case, why is it not an intoxication?
It's a causation issue, Judge. We looked at it for an upgrade, is my understanding, because the other vehicle was on the roadway. Legally speaking, there's a causation problem, Judge, so that's why we came to the agreement that we have the families on board.
I'm not, sorry, I'm not gonna say it. You have a dead body here. She has cocaine in the system. She's got foods in the car while she's driving and a dead body. I'm not down with that. No, we're gonna have to do something else, but I would be remiss a week in jail where we have a dead body.
Yes, sir.
And to me, just because you're 9 months pregnant doesn't factor anywhere in my mind, Ms. Sanchez. Ma'am, look at me. While you're about to give life, you took someone else's life. I'm sorry. How many lives are now ruined because of this? Not only yours, how about everybody else? Every single day in Harris County, someone is maimed because of the DWI. It's sick that we lead the nation in fatalities. And I don't know why they can't prove causation to charge you with intoxication and manslaughter. But to me, a week is insufficient. It's not enough.
Yes, sir.
So
We'll go back to the drawing board and get
go
a
back,
reset, Judge.
but
Yes, sir.
I'm ready to set this case for trial now. So unless we can work something out today, I'm saying it gets set today.
Yes, sir.
Okay.
All right, thank you, Judge.
Your Honor, I understand that a fatality did occur, but the reason why they weren't able to charge my client with intox manslaughter is because this accident was unavoidable. If you were
Unavoidable?
yes, sir. At the time of this accident, it was unavoidable. What ended up happening is that the deceased party spun out in front of her, and she was just going straight. The only thing that she did wrong at the day and time was drive a vehicle.
With cocaine, alcohol in her system, beer in the car at a 0.20. Let me ask you something. Have you ever done breath test? Have you ever blown into a breath test machine? Have you ever done those wet labs? You ever done that?
Your Honor, okay.
I'm serious, really.
Okay.
Have you ever done it?
I'll go one further, Your Honor. Before being a defense attorney, I was a lieutenant with HPD.
Okay.
So I'm above and beyond. I spent 3 years doing accident division. So not only did I investigated these. So my knowledge is probably more superior than anybody in the room. I spent 3 years picking up dead bodies. And that is a true and factual statement I'm making before the court. So yes, sir, I have.
I did, as part of training when I was a defense lawyer, I went to these classes where we took the breath test machines apart, did all kinds of experiments, did these drinking wet labs where you drink and then you blow into the machine. And the one time we did it, we downed a bunch of booze and I blew into the machine and I was lit, right? And I blew a 14 and I was lit, man. And now all I did was I blew a 14, right? 0.14. She's at a 0.2.
0.025, Judge. 0.025.
0.02.
Yes, sir.
Okay. I thought you said 0.20.
No, sir, no, it's 0.025 with the cocaine and THC.
No, so she's not 3 times or 4 times over the legal limit, Your Honor.
We were discussing about Ms. Sanchez. We were discussing when for you to do your jail time. Should we have you do it immediately to where you have the baby in jail? Is that cruel and unusual punishment? But then again, is a dead body cruel and unusual punishment? You know, what's fair? What's not fair? I don't know. All I know is that you're charged with DWI. There's a dead body, but they just can't prove causation. And that's why you're not charged with manslaughter. But the fact remains is that we have a dead body. How do we reconcile that? You know, you're pregnant now, and I truly hope that you've treated your body well throughout that pregnancy. Because if you haven't, and you've used anything while you're on probation, you're guaranteeing yourself a life of babysitting of a potential baby that will have developmental, potential psychological, physiological issues that you'll have to babysit for the rest of your life, which is punishment in and of itself. It's not fun. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you guys have worked out is 30 days in jail as a condition to probation for 18 months. As part of the probation, does she have any prior DWI staff?
No, Judge.
Any other criminal history?
Juvenile history only, Your Honor, but nothing DWI.
What all were you wanting done on the probation? Correct.
Yes, sir. We are asking for DWI education class, a victim impact panel, guardian interlock, no refusal, no drugs or alcohol, random UAs, 80 hours of community service, and a $300 donation to MAP.
Is this how you understand the conditions, Ms. Sanchez? I will keep you to it strictly. I'm going to monitor you myself. You will report to me here to the court so that I make sure everything gets done well. If you are not in compliance, I will issue a warrant for your arrest. You will be put into jail, and then you'll be facing up to 180 days in jail. If you test positive for alcohol or any kind of drugs, I will put you in a treatment facility in the jail. Do you understand, ma'am? No alcohol, no dope, no driving. You must have what does she have now? Does she have a scram right now? Do we know if she's had any violations while she's been on? I don't think so,
I
right?
don't
She hasn't
see
any
any,
problem.
Judge, no.
Okay.
She has a scram device at this time, Your Honor.
We have to figure out something about as far as the baby situation with the interlock or with the portable device. I will follow the state's agreement here. But like I said, I'm keeping you close to me. From now on, you'll be facing a minimum of 30 days in jail if you ever pick up another DWI. Do you understand? You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, if possible immigration consequence, you can be deported, excluded from the country, denied naturalization under federal law. Hey, if you can do the repeat offender to get the education class. Did you say victim impact panel?
Yes, sir.
How many?
One.
One victim impact panel. You will be required to do a TRAS, which is an evaluation to see what other conditions you may need. You must fulfill those conditions. Guardian interlock, no drugs, alcohol, random UA. When are you set to deliver, ma'am? What day?
August 28th.
When do you think we should do the time?
If I could request anything, Your Honor, it'd be the beginning of the year, in January 2025, the start of the year. That gives her time to nurse her baby and everything else.
She must get it done within 6 months. Okay. All right, ma'am, how do you plead to the offense, guilty or not guilty? And we'll find you guilty. We'll send you to the disagreement. Good luck to you, ma'am. Please see the clerk. This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
Says 19, Your Honor. That's 7, within that 7 are included. But Judge, I would ask if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So that he can
I'm
do-
sorry, Ben, I can't. I have to know, you have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, Your Honor, cold weather. I apologize. So can I please speak on the breathalyzers?
No. You know what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please,
No.
And
It's you.
but to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate, for alcohol.
I go to sleep early.
Test. And he is blowing outside the window, so we don't know what he's doing.
My God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pretrial over there, and they said that I had
you.
a 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor, I will do anything. I'll even go on that drug, ankle monitor. I'll do anything, Your Honor. I'm really trying here. I swear to God, I will do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor, it's just, I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I do wake up. And they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one
I started
pass after the other. He goes with you. No.
Oh my God.
Your Honor, may we discuss setting a new bond for
Of course.
Oh my gosh. Your Honor. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I'll now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view it. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera, then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, it's I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 7502, Judge, for
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't, but, fine, because. Fine. All right, 7502.
She sent me an email from, one of
If
the.
anything, have you done for your GED?
And what I did for it,
What have you done?
I went to a class and then I tried to go yesterday. They canceled it and he also.
You went the day before court.
And I also went before.
Judge, she's been going. She's been going before even the last court date, and we, you know,
Prove it.
I can text you.
In this life, you are only as good as the proof that you don't have. If you don't have proof, you have nothing. Spoken word means absolutely nothing.
Judge, the instructor, I got an email from him that she sent me saying that she's been going to the classes and that class was canceled on the 4th yesterday. But she did, you know, attempt to go to class. So she's been going, she did already take a test, and this is the one where she did fail the first test. So she's been working on it. It's not enough.
I mean, here we are. How many resets have we had? We've had 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 resets since May. You're now in December. You have had 5 to 6 months. Show me the money. Otherwise, it's not going to go well for you today, Ms. Dixon. Show me. 5 to 6 months.
And Judge, this was a case where she was paying for the classes and then she had to then enroll into the free program, which she's been doing for the last little bit.
Are you playing Candy Crush? What's going on over there?
I'm trying to text you.
Texting who?
The instructor, like what I'm supposed to show you. Cause I don't have no proof, like I don't have nothing.
Tell me what have you done?
I went to the class,
Okay. Which class did you go
the
to?
GED resource.
Okay. And because the way I understand it, there are different modules that you do. You do science, you do language arts, you do math, you do, and whatever else it may be. You go through each section, you complete it, take a test, and then when you're done with everything, you take an overall test, and then you get a diploma.
That's not.
What have you done?
Basically explaining how everything's gonna go, and I was gonna finish everything else Wednesday when I was gonna go, but the class was canceled.
Who is the provider that you have?
His name is.
Grab me a phone number, because I'd like to call them right now. Yes, my name is David Fleischer. I'm a judge here in Harris County. And I have someone that's with me in our court, and she's doing a program with you guys to try to get a GED. I'd like to confirm that's Coriel Dixon. So Wednesday and Thursday, and then did you say every other Saturday? Okay. And then, so how does it work as far as getting the diploma? Do you do different classes as far as science, math, and how do you at the end get it? Can I put you, I have her in front of me. Can I put you on speakerphone so that she can hear this as well? Do you mind? Okay, hold on. So I've got him. Okay, Mr. Jackson?
Order in the court, please.
Okay, tell me, how goes it?
So, yeah, it's kind of twofold. They take an assessment. Based on that assessment, allows me to know where the student is as far as their grade level in math and in reading. Based on that, they go on 2 tracks. And so one track is like a basic education where we're just literally working on kind of some elementary reading and math skills.
Okay.
Or a GED track where they're ready for GED contests. And so, yeah, and I usually just, go from there. I work with my GED students individually. And
how long does the process take? And how long can we expect it?
Well, so that's honestly kind of a loaded question. Depends on where they fall. I believe Coriel scored pretty well.
Great.
So yeah, and I've worked with people that have gotten the GED in 3 weeks. I worked with people that have gotten the GED in 2 years.
Oh, yeah. I can't do 3 years. That's too much.
Well,
I know, I'm kidding.
No, I understand that.
She's been faithfully attending though? Yay or nay?
Yes.
Okay, great.
And with some consistency, 3 to 4 months, maybe less.
That sounds great.
That's just me ballparking.
I'd like to stick with it because I think at the end of the game, our goal here is that she ends with that diploma. And I think that would be a win for everybody. I'm calling you. I want to make sure that everything's going well, that she's attending, faithfully attending and doing well. And it sounds like you're saying that this is what's been happening.
Yes.
Great. Okay, so I'm just going to continue everything. Just continue to go, Miss Dixon. I mean, you got like what he's saying. If you continue at it 2 to 3 months, you'll end up with your diploma. Okay. All right. Thank you so much, Mr. Jackson. I really appreciate your help. You've been great.
No problem, Judge. You take
Okay.
care.
You too. Thank you, sir. Bye. Great. Good job. Just keep at it. Okay. So let's set it 30 days. I want to ride this through. You're so close to being through. All you got to do is see it to the end, and then everything great will happen for you here as well. Okay. All right. All I know is that you have picked up a case from out of state. And well, give me a second and I will let you, but here, so we're not disputing the underlying charge. We're not fighting it. None of that matters. What we really here are all about is identity, right? Are you this person? If so, how do we get you back to the jurisdiction that you're wanted from? So here it says that you are wanted from Michigan, Washtenaw, Michigan.
Washtenaw County, yes.
Yeah, Washtenaw County. And it says here that you're wanted out of there for armed robbery. So I know that you're going to tell me it's little bunnies jumping in the woods. It's not that big of a deal, yada, yada, yada. But my primary concern is public safety. We have enough death, dismemberment, and hysteria in Harris County as it is. And I don't want any more blood on my hands. You know what I mean?
Yes, sir.
Shh. So your lawyer is asking me to set you a bond. And I don't know, because if you're a public danger, I'm going to have a hard time doing it. Right?
Understandable, Your Honor.
Oh, Miss Chisholm's not even here.
She just jumped off because she was just up there.
May I speak, Your Honor?
Your lawyer's not here.
Okay.
So until your lawyer gets back, I'm not going to let you go. I'm going to bring you back out, but your lawyer's not here. I can't talk to you without your lawyer here. So I'll bring you back out here as soon as she gets back, and then we'll go right through the rigmarole again. Okay? Sorry. I didn't even realize she's not here. Mr. Thurman, you're back. Okay. So I told you before, two of my main concerns are, or my two main concerns are, number one, are you going to go back to the jurisdiction that where you're wanted from? And number two, most importantly, are you a danger to my public? I take public, safety. It's as important as my hair. You know what I mean? It's that important, right? Because I don't want anything to happen out there with my name attached to a bond. I try everything in my power to ensure that everybody's protected. And I see that you're wanted for a really serious case. It's an armed robbery, right? I mean, that's what you're wanted for. There's no denying it. That's what it says on the paperwork.
He's on lifetime probation in Michigan.
Lifetime? There's such a thing as lifetime probation?
Yes.
Whoa.
So that Kate, I'll let you do the talking.
No, he did his time and he got out and lifetime probation out of Michigan. So that's what's happened. I believe it got.
So how on what would, aside from like a murder case,
So he was
what
charged
would
with
garner?
murder twice, along with 2 armed robberies.
I wasn't charged twice for no murder.
It just shows up.
It just shows up
Oh, I was about to say, I wasn't charged
Murder
twice.
along with armed robbery or aggravated robbery in our jurisdiction. He's placed on probation. Since that time, he's been charged in our jurisdiction with aggravated assault with a deadly weapon and felon possession of a weapon. In those, he had bond conditions when it started off, where he was ordered to have a GPS monitor. He has had multiple curfew violations on top of that noted. And so I do believe he's a safety risk, because even with literally an ankle monitor, he doesn't follow court conditions. And so I believe he is a safety and flight risk. And the fact that there was a weapon involved with multiple witnesses, some of them children, even threatening to murder them, is that I would be opposed to a bond being set. Also, it should be noted that because of the way the probation was transferred, I can't confirm, so I can't approach on it yet. But from what I see on the system is that he moved the probation to Texas, which means there's an ICA. But I don't have the documents, which is why I can't present them. If there's an ICA hold, he is ineligible for a bond, because that's an ICA hold. I don't have it, which is why I can't say. But if I get the documents.
Interstate compact agreement.
I understand. May I speak, Your Honor? Of course. Okay. After we talking about the probation, I'm at the probation, the GPS curfew wise, my judge knows all that was going on. So he knows every information and why I've been late. I have evidence of why I'm late. So he knows everything that's going on with my GPS.
You're not supposed to be late.
He knows why though.
I understand.
That's why he overlooked. He said, okay, it's fine. He said it was fine.
Quick question, is it a motion to adjudicate?
Well, no, it's still an open case. It's not under probation, but you're just asking if they do a bond violation report. They did on November 1st, 2024. They filed a motion to revoke.
Oh, so it's recent.
It's very recent.
So they've not
this month.
heard, okay, and then so there's not been a hearing on that yet, right?
No, but that's even after they amended the order. Also, he has further bond violation reports on December 18, 2023, another one on November 28, 2023, and that's after they amended it twice. One moment. So he seems to be agreeing with this. So the fact that he has 3 violations on top of having lifetime probation and a possible ICA, obviously, I'm still opposed for him.
Why are you on lifetime probation?
That's the way they set it up as. I took the plea deal.
What are you on probation for?
The armed robbery conspiracy committing armed robbery. I did 5.5 years. Came home off lifetime probation. And to continue what I was saying, so I'm a threat to, a flight risk. I can't be a flight risk. Every court that they set, I came every single time. Every court that Michigan have set, I flew out there every single time. I knew I was getting locked up Monday. They told me that Thursday. I still showed up to court and got locked up. So there's no flight risk in this whatsoever if I've been showing up every single time.
And you may be showing up, but at the end of the day, you continue to do what you want to do without regard to bond conditions.
And what do you mean by that, Your Honor?
Meaning that they put you a GPS monitor, and they give you a curfew.
Yes.
And you don't abide by the curfew.
I was working, Your Honor. That's why the judge has stated, because they had my probation curfew time at us. I forgot what time it had as, but I had started my new job because I came, got locked up, lost my other job. He said, okay, the violation he's talking about, I came into court and talked to the judge, and he extended my curfew. He was like, okay, we've been working. I said, yes, I have documentation of new work. So I'll show all my documentation, and he said, okay. So the stuff he's mentioning violations for, they already been taken care of. So he's not stating that either. He said 2023 is, oh, obviously I'm still free, right or wrong. I'm still free. That means he's seen all the paperwork. Obviously, I came with legit paperwork.
And that's kind of where I was coming from at it. If it's a lifetime probation and it's curfew violations that he's still out, my speculation would be that he was able to make an explanation to the judge, and that's why he's not been revoked. So he's still here. As to the underlying charge, it's still a charge and that's what it is. Like he said, he turned himself in on Thursday knowing that he was going to get arrested and held. And so I'm sure that Michigan it's a probation violation because of the underlying charges. And plus, that's where that MRP is probably coming from. I believe he's proven time and time again that he's gone to Michigan, taking care of what he needs to take care of, and he will still be here he's been on bond on the underlying case for about a year, Your Honor. He's not been locked up this whole time up until this recent arrest. So, and at this point in time, this is really just for if since we don't have proof of an ICA, if the judge is willing to set a bond, how much that would be, if there's a willingness to set a bond.
Let me read this to you.
Yes, Judge.
Texas Code of Criminal Procedure 17.03. NLR, out of state Michigan, armed robbery, armed robbery with a conspiracy, 2021. Probation transferred to Texas 3/20/21. Concurrently charged with murder, which was dismissed. No holds. Defendant is not indigent, and defendant is alleged to have gone to complaining witness's home and pointed a gun at complaining witness and complaining witness's 3 children because one of the complaining witness's children was involved in a dispute with defendant's sister at the child's school. Defendant threatened to kill, quote unquote, everyone in the home. Defendant then left complaining witness's home and came back with defendant's father, both ready to fight complaining witness and complaining witness's wife. That's the aggravated assault that we have now. So, knowing that you're on lifetime probation for a very serious case, you know that you're supposed to be out there with a halo over your head. And yet you pick up an aggravated assault with a deadly weapon where allegedly a gun is pointed at kids. I mean, the way your mannerisms.
I would say something, Your Honor, that's why.
But don't, though. You have this open case.
Understandable.
Everything they can say, they can use it against you. My concern is public safety, man. And you got to understand that I don't know if you're guilty of this offense or not, but the problem is bad stuff keeps happening to you for some reason. It's like somehow, sometimes people are their own worst enemy. They get out and then something happens and then they just end up picking up another charge. It's like a cold. You pick up another charge, you pick up another charge here, you pick up another charge there, you don't follow bond conditions here. Mr. Thurman, you scare me, man.
Yeah, I scare you, Your Honor?
Yeah.
And I've been out for a whole year since this case happened, and this is my first time being into this courtroom again, and you're fearful whose safety if I've been doing nothing but right and working.
That's not true.
That has been true. I've been out for a year on bond and I have not been into this no courtroom, but in Orange Jumpsuit, I should say. Your courtroom, anybody's
you
courtroom.
want me to reward you for being
but you say you're in fear. You say you're in fear for safety. That's what I'm saying. Like, who are you in fear of? I have not been into any trouble whatsoever. I've been squeaky clean. Just I bonded out.
And Your Honor,
You don't get rewarded for being a good person out there. You know what I mean? You're supposed to be like that anyways.
I understand that wholeheartedly, Your Honor. I'm just saying, you say you fear, and I'm saying, how are you in fear if I've not been doing anything? That's showing you, that should show you some type of sign, like, okay, he's not been doing anything wrong. So where is the fear come to play? That's what I'm asking you.
The fear is really because, when people come here, it's little bunnies jumping in the woods, rainbows, gumdrops. And then when they get out there, they turn into different people. It's like Jekyll and Hyde. And I don't want that. Like, I don't want someone out there to suffer because we let you out, I let you bond out. You've got an armed robbery, you've got an ag assault. You continue to violate conditions on those bond, right? That shows me that you're not willing to abide by bond. I mean, quite frankly, you're lucky to even be out on those charges with the ankle monitor, and you continue to violate.
And Your Honor, you keep saying violate, like, if I was in violations they have on file, by the way. Those have been taken care of. Once again, you keep on saying violations, but they took care of. The felony court judge seeing I have proven, what's the word I'm looking for? Just proven, facts that this is why I'm late. I have a new job. I got fired because I got arrested from the other job. So I started a new job. For me having a felony in my position, and just call it what it is, a young black man with a felony, it's hard for me to get a job anywhere. So the jobs I do get, I take up on those. So it's hard for any shift they open up for me, I'm going to take it and show my work ethic to them. So I let the judge know that. He sees that. He understands, like, okay, that's why you keep on bringing up violations. I have to work. I have to eat. I have to have a house to live in, like anybody else here. So you keep on bringing that up. I'll keep saying, I already talked to the judge about it. He granted it already. He let it go. That's why I'm still free to this day. Well, was free to this day. And you keep bringing that up. You saying threat to your fear, which is understandable. Everybody gonna have fear, but I have not been into any trouble. I've been working. I've been working for a whole year. I've been on my P's and Q's. And like you say, the police report that you're reading, sir, the case is still open, so I can't really speak on it. I'm pretty say much, but it's a lot more to what you're just reading on that police report. It's always going to be video cameras and house ring cameras, body footage. It's going to be a lot more other things that you're not going to be able to read off a police report, which is understandable.
Just too much blood, Mr. Thurman. I'm sorry. I can't set you a bond. It's just too much. I'm sorry. Hey, this isn't.
Do not walk away.
This isn't.
I said, okay, it's fine.
Really, I understand that you're hurt, Mr. Thurman, but look.
I've been doing my best, Your Honor. And y'all sit here telling me I'm the bad guy, and I've been doing nothing but my best of my abilities, working, staying out of trouble. And you're a threat, and I'm a threat to society. Really? For a whole year, I've been out, and they just not issue a warrant for me just now, recently. And I come to turn myself in, and I'm a threat to society. And people, you fear me for what? From turning myself in and show you that I'm not running for nothing. I'm not running for anything. I'm innocent, and I'm coming to show you I'm innocent by turning myself in. But y'all a threat. You can let go of me, sir.
Stop.
You can let go of me.
You don't not tell me how to do my job.
You can let go of me. You grab my arm too tight.
Guys, relax. Relax.
I'm too tight. All I said, grab me. Look how you grabbing me up.
Back up.
Look how they grab me. I said you let me go a little bit.
You gotta calm down.
I'm calm. I just asked him a question. I asked him if you let me go a little bit, sir. That's all I said.
Open the door.
That's all I said. When you make somebody cuss you out, what do you think? You said I'm all tight. You just look. You know.
So he already waived, so if
He did.
holds it, then it's.
Just, yeah, I can't.
I'll go talk to him, but once again, Judge, understandably, I think I know that he's frustrated. I believe.
I understand. I get it. And I would be too, but I can't. That's just too much blood. It's too much.
It looked like there was.
Even, what I'm going to tell you, even if he didn't have those bond violations, I'd still be very hard pressed to even,
No, and I was curious because when you brought it up, it was a little bit older, and so I was wondering why.
Do you know, are they going to come get him?
I'm not gonna get him. I was trying to figure out why now, and they were just having back and forth.
But here's the problem. So he hasn't made bond on those cases. So we're sitting anyways.
Yeah.
He has not?
No.
He said he did.
No, he's not made bond on those cases. He's
been in jail for a year?
No.
He may have, but they revoked the bond.
Ah.
Yes.
So he's sitting there, and I didn't have the heart to tell him right now that the 14 days is not going to apply.
Yeah.
Because
I gotta do that.
I will. I really.
I will. I'll let him know.
I'd imagine it's gonna get resolved because it's one of those. It's a bizarre. So we revoked. Harris County revoked because Michigan revoked because it was charged with the ag assault. So it's a chain of events because the only thing the court sees is that they revoked on the probation, which was called.
Please let him know that the 14 days hasn't kicked in, and it will not.
It will not kick in.
Resolves.
Right.
And either he resolves the cases.
So which one does he need to resolve first in order for?
Well, for the felon possession of the weapon, there's.
Is there an offer?
No, it's going to trial. That's why it's been reset out. It's been set for jury trial at least.
Four times.
4 times. 1,
Yeah.
2, 3, 4, 5. Yeah.
5 times, Judge.
Next time is January 6th, 2025. But he's held on 55,000 bond for the ag assault and 55,000 for the felon possession. So he has to come up with 110,000 for.
Wait a second, so
So it doesn't matter what you did today.
can't, even if I gave him a bond today, he would still have to make those bonds.
110,000.
So my question now is, when did that warrant for the felonies pick? Because he's saying he's been out for a year ever since this
I'll
ag
explain
assault got picked up.
I show a remand defendant custody on November 18th, but I don't know what the previous.
So the only reason why his felony bonds got revoked was because Michigan revoked.
Oh, no, it doesn't, but we don't know that for sure.
Yeah.
Because there's no notes that reflect why they revoked the bond. It just says court directive remand defendant to custody. Let me see if they give an explanation. Hold on.
Okay.
It's remand to custody, violation report, but that's not a revocation. Yeah, because.
It's a violation